Republicans are yet again asking the Supreme Court to adopt a radical legal theory that could upend American elections. The so-called independent state legislature theory, or ISL theory, is a right-wing interpretation of the U.S. Constitution that says that state legislatures have the sole authority to regulate federal elections, free from constraints by state laws, state constitutions, and state courts. Adoption of this theory could give state legislatures free rein to gerrymander electoral districts and enact suppressive voting laws without state courts being able to intervene. The most extreme versions of the ISL theory could even prohibit a governor from vetoing an election law or map and prevent citizen-led ballot measures about federal elections. 9 Republican secretaries of state and 11 House Republicans filed briefs in a Pennsylvania election case urging the Supreme Court to adopt this theory. And most recently, Montana's Republican Secretary of State and Attorney General are peddling this theory in a separate case over 4 voter suppression laws in the state. But the Supreme Court already rejected this theory in a 6-3 opinion issued last summer in a case called Moore v. Harper. The court held that the Elections Clause does not vest exclusive and independent authority in state legislatures to set the rules regarding federal elections, and does not insulate state legislatures from the ordinary exercise of state judicial review. Chief Justice John Roberts issued the majority opinion and was joined by Brett Kavanaugh, Amy Coney Barrett, and the 3 liberal justices. Justices Thomas, Alito, and Gorsuch dissented. In this new Pennsylvania case, state Republicans are challenging one of President Biden's executive orders that told state agencies to expand voter registration opportunities. The GOP lawmakers are using this discredited ISL theory to argue that President Biden's executive order somehow encroaches on their legislative power. Now, not only are Pennsylvania Republicans pushing this ISL theory in SCOTUS, so are secretaries of state and House members through amicus or friend of the court briefs. Though these types of briefs are not from the actual parties in the case, they are often cited by justices in their final opinions and reveal the priorities of those who take the time to submit them. And in the separate case out of Montana, state Republican officials intend to appeal a decision from the Montana Supreme Court that struck down 4 voter suppression laws to the U.S. Supreme Court. In a brief to the U.S. Supreme Court, Montana Secretary of State Christy Jacobson asked the court to reconsider the ISL theory. Jacobson acknowledges the court's decision in Moore v. Harper, but says that the court left open the question of how to determine whether a state court has transgressed that boundary and impermissibly interfered with the state legislature's authority. The Supreme Court has not yet agreed whether it will even hear either of these cases, but it is clear that Republicans will continue to push this radical theory. Thanks for watching Democracy Docket. If you want to stay up to date on the latest voting and election news in the courts, make sure to subscribe to our newsletters. You can click the link on the screen or in the description of this video. I'm Sophie, and I'll see you next time.